to the first panel, and I'm very happy to introduce a very nice panel, very nice panelists, Burkhard Hess, Stefaan, Voet, and Sandrine Giroud, and I will introduce them one by one once they start their speeches, of course. So as I mentioned briefly in my introduction, in recent years, courts have been set up in European, Asian countries, as well as in the Middle East. And while quite often these courts have been viewed from a competitive perspective, we also had the kickoff keynote focusing more on collaboration. And it is also nice to hear that this collaboration indeed also takes place, including in my home country, the Netherlands, and England, where I am today. In the Netherlands, so the Netherlands is also one of the countries where a commercial court has been set up, as many or most of you will know, and that is the Netherlands Commercial Court, the NCC. And that actually started its work in January 2019 and has been dealing with a series of cases, international commercial cases since then. And this Netherlands Commercial Court consists of highly qualified and experienced judges that have been selected from the Netherlands based upon their experience with, of course, international commercial cases, English language skills, etc. And though it was not fully new that we had proceedings in England, because also in the Rotterdam court, for instance, where you have a chamber focusing on maritime cases, English was or could be used as a language for litigation. But still, the new Netherlands Commercial Court having a fully fledged English procedures from head to tail, including the decision, is quite innovative, backed up with a couple of new procedural rules that should stand the challenge of international business. The motto that is being used, and which you can also read on the website, the English language website of the Netherlands Commercial Court, is pioneering English language dispute resolution in a civil law jurisdiction. And that is also where you see the combination. And of course, the Netherlands is a civil law jurisdiction, but with an open view also to, of course, international standards, but also to the applicable law and procedural rules in the common law countries. We will hear a little bit more about the Netherlands Commercial Court in our panel on a practitioner's perspective, where we also have a speaker of the Netherlands. So I will stop now about the Netherlands and give the floor to our first speaker, Burkhard Hess. And Burkhard Hess, well, I'm sure you all know him. He's the director of the Max Planck Institute for Procedural Law in Luxembourg, and also honorary professor at the Universities of Luxembourg and of Heidelberg. And of course, he's a renowned expert in the area of civil procedure, European civil procedure, and international civil procedure. And also he has a dedicated expertise on international commercial courts, having been involved in the setting up of commercial courts in Germany. So Burkhard, I'm happy to have you here again. Well, not literally physically here in London, but at least on the screen. And back then in 2018, the conference, the seminar that we had on international commercial courts in Rotterdam in July 2018 was also co-organized by you, and you were also one of the speakers. So happy to have this follow-up 3 years later. The floor is yours, Burkhard.
Thank you, Sandra. The happiness is also on my side, and I would like to share a small PowerPoint presentation to give you an update on the developments in Germany. I don't know whether I can do it. Maybe now it's possible. Let me see. Just a moment. Oh, it does not really work, it seems. Sorry for the moment, the delay.
I hear here that it should work. It should work. So
it should work, but I can't see what I want to show to you on my screen. That's the interesting issue. Okay. I leave it like this. I will tell you something about the latest developments in Germany since 2018. And especially I would like to address the new international commercial courts in Mannheim and in Stuttgart, because there is something going on which is new. So if one looks at the present state of affairs of commercial courts in Germany, the development started in 2010. Pilot projects in Bonn and Cologne where hearings could be conducted in English, but almost no case law has happened in these courts. So in 2018, additional specialized chambers for international commercial matters were established at the regional courts of Frankfurt and Hamburg. But to be quite open, again, there is not much case law going on. So now we have a third attempt. Last year, international commercial courts have been established in Mannheim and in Stuttgart. And it's a little bit a pity that I cannot show to you the web page of this court, because these courts are different. They are different because they are accompanied by a communication strategy, which is very well seen at the web pages of this court. You can see in these courts and at the web page photos of the judges. You have also information about their bios. And especially there is an advertisement regarding their skills, not only being judges in the judiciary, but also about their practical experiences outside of the judiciary. This is a little bit copying the English model to demonstrate that judges are not only have not only experience from the bench, but also have practiced as lawyers. And this is totally different and new for Germany, because usually if you go at the web page of a German court, you will see the court building and maybe a photograph of the president of the court. That's it. And you don't see the justices you are going to meet. So this is a service-oriented approach, and especially the International Commercial Court in Stuttgart has its building close to the airport, with facilities also for the parties to meet in separate meeting rooms. IT equipment is available, but there is one deficiency. And this is the other side of the German development, the missing legal foundation for the new international commercial courts. According to German law, all proceedings need to be held in the German language. Parties may agree that the hearings themselves are conducted in English, but still all paperwork, and this means in Germany paperwork in the proper sense of the word, because digitalization is lagging behind, is to be made in the German language. With the international commercial courts, it shall be different. However, there is a kind of political debate which is not so dissimilar from the Belgian situation. So at the level of the federal states in Germany, especially now Baden-Württemberg, where the Mannheim and Stuttgart courts have been established, they try to introduce legislation permitting those new courts to operate fully in English. However, there is a lot of resistance within the Federal Ministry of Justice. The reasons are political ones. There is this feeling that one should not privilege a specific group of plaintiffs or of parties. And therefore, 4 times since 2010, initiatives to start legislation and to adopt legislation have failed. And the last initiative dates from March of this year, and it will fail again because the German parliament will be dissolved in a couple of days, let's put it that way, and then they have to restart the legislative process again. So what are the ideas in order to improve international commercial courts in Germany? There are some interesting features now. They want to set up a jurisdiction not at the district court level, but at the level of the Court of Appeals. And only disputes with a value of amount transgressing 2 million euro shall be brought to these courts. All proceedings shall be conducted in English. Within the commercial courts, always a panel of 3 judges shall decide the dispute, and special procedural rules shall apply for permitting case management. And finally, court fees will be duplicated. I would like to finish this short intervention here by answering to the question Xandra has already raised when she sent an email to us. Are international commercial courts really needed? And from a German perspective, I would say, yes, they are. According to statistics, almost 500 disputes per year are decided by German courts with an amount of more than 2 million euros. So there is a kind of domestic market for that. And by establishing these commercial courts, the German legislator may fight against a general trend that less and less cases go to German civil courts. We have dramatic decrease by 30 to 40% of civil cases since 10, 15 years. And this is, of course, something which raises a lot of concern. And in this regard, international commercial courts can be an incentive to modernize the general justice system. And this is why it is important to have these international courts installed. Thank you very much for your attention. I'm sorry that I could not show you my PowerPoint, but I hope it was understandable. Thanks.
Thank you very much, Burkhard. We're sorry that the PowerPoint, could you please send them, because apparently it's not possible to share the screen. And if we show them here, then at least in our panel discussion, perhaps you can still show some of the slides that you wanted to show to illustrate your point. But I think it was a very clear story. So thank you very much for that. Well, now I see slides that should not be shown perhaps yet. Yeah, oh yeah, it will be the next slides. But what I wanted to say to wrap up, and it's good that you already started a bit of the discussion, because what I had proposed for this panel, but of course we will first have the introductions, is indeed asking in how far these courts are really truly international, looking for instance at the composition of the courts and also the language, in how far they really distinguish themselves from other domestic courts, and also whether there's a general need. And Professor Hess already answered the last question, the general needs, but maybe perhaps later on in a panel discussion, and also maybe with intervention of the public, we can dive a little bit further into the question. Now we have slides on the screen for our next speaker, which is Man Yip. And she is associate professor at the School of Law of the Singapore Management University. So we're very happy to have you here on the screen as well. You're also director of the Center for Commercial Law in Asia, and she also has a wide expertise in the area of international commercial courts. And of course, Singapore is a very important country also in this area. We also published a book in 2019 on the topic, and a journal issue, and also Man Yip participated in that. So we know already that she has a lot of knowledge on the topic, and we're very happy to hear your views today. So the floor is yours.
Thank you. So just to check that you can hear me. Thank you very much. Very warm good afternoon from Singapore, right? Because it's a tropical country. First of all, I would like to thank the organizers, Eva and Xandra, for inviting me to speak about the Singapore International Commercial Court, or the SICC for short. Now, I've been told to be brief about it so that we can have more time for questions and discussion. Now, the Singaporean version of the International Commercial Court was clearly inspired by the English Commercial Court. It launched into operation in January 2015. It is now in its 7th year of operation. The SICC is meant to increase the dispute resolution options offered by Singapore to the international business community alongside arbitration and mediation, thereby enhancing Singapore's reputation as a leading dispute resolution hub. All courts in Singapore, including the SICC, are English-speaking courts. In the pre-launch feasibility report, it is stated that the SICC feels the need for a neutral and well-regarded dispute resolution hub in Asia. The design of the International Commercial Court, however, if we take a closer look, is not limited to the pursuit of regional prominence. There is nothing that is particularly Asian about it, if you ask me. However, this Asian marketing angle from a branding viewpoint does accentuate the geographical and perhaps also the cultural advantage of the SICC in handling disputes involving Asian elements. And I think that's how it sets itself apart from the very developed and popular dispute resolution mechanisms created and based in other jurisdictions, particularly the Western countries. Now, to be clear, the SICC is a national court. It is not a truly independent international court. It is established as a division of the General Division of the Singapore High Court. Appeals on the SICC judgment are to be heard by the Apex Court of the Land, the Singapore Court of Appeal. So one might ask, which is one of the questions posed to us by Xandra, is then how international and or in what way is the SICC international? And I think that's a great question. So I would suggest that there are 3 senses in which the SICC is international. First, it was conceived as a court that would incorporate international best practices in dispute resolution. And for this reason, many features of the SICC are adapted from the features of international commercial arbitration. The SICC framework has been famously described as a careful marriage between arbitration and litigation. And even more recently, in one of the webinars hosted by the SICC user experience is being branded as arbitration and litigation. Now, if you see the comparison table I put here, comparing between the SICC framework, traditional litigation before the Singapore High Court, and international commercial arbitration, you can see that many of the SICC procedural rules are indeed adapted from the arbitration procedural features. Right? For example, you have the possibility of dealing with foreign law on the basis of submissions, as opposed to the more extensive way of proof of foreign law, which is the method in common law jurisdictions. You can also obtain confidentiality orders in respect of both the proceedings and outcomes, much more easily than in High Court traditional proceedings. There's also greater latitude for foreign lawyer representation in what are known as offshore cases in SICC proceedings. These are essentially cases that have no substantial connection with Singapore. You can also apply foreign rules of evidence, or in fact, rules of evidence that do not belong to any particular legal system in the SICC proceedings. So these are features that are adapted from arbitration practice. Now, they're adapted and not imported wholesale because parties' consent by itself is not determinative of the availability of the relevant procedural feature. As a court and not an arbitral tribunal, the jurisdiction and power of the SICC is not circumscribed by parties' consent. And for this reason, an often touted advantage which the SICC has over commercial arbitration is that it has coercive powers to compel third parties and related parties within its jurisdiction to be joined to the proceedings. Now, the second sense in which the SICC is international is that it is designed to only hear international commercial disputes. The subject matter of the General Division of the Singapore High Court, on the other hand, is not so limited. It hears a mixture of domestic disputes and international disputes, commercial or non-commercial. Now, returning to the SICC, I might just want to mention here that a case can be considered as international in nature for the purpose of being decided in the SICC if parties expressly agree that the subject matter of the claim relates to more than one state. This is, however, subject to the oversight of the SICC. The court may still decline to hear the dispute if it finds that it is not truly international in nature. Now, the third sense in which the SICC is international is that it takes a more liberal, and I would say international perspective of its own extraterritorial jurisdiction. Now, here we put to one side the SICC's supervisory jurisdiction to hear proceedings relating to international commercial arbitration, and instead let's just focus on its jurisdiction to hear general international commercial disputes. There are two main ways in which such disputes can come before the SICC. First, if these disputes were filed with the General Division of the High Court, they can be transferred, if appropriate, right, to the SICC for resolution. Second, where there is a written jurisdiction agreement designating the SICC as a forum for dispute resolution, and the relevant dispute falls within the scope of the clause. Now, in this second scenario, where there is a written jurisdiction agreement, there is no need for the plaintiff to seek court leave to serve out of Singapore, unlike traditional litigation proceedings before the General Division of the High Court, where court leave is required to serve out of Singapore. This implicitly accepts that party autonomy or consensual jurisdiction is by itself sufficient for the SICC to exercise extraterritorial jurisdiction. Further, whether the jurisdiction agreement is exclusive or non-exclusive in nature, the SICC cannot decline to hear the case solely on the basis that the dispute is connected to a foreign forum other than Singapore. I think connections to competing fora are downplayed because the SICC is in that sense portrayed as international or neutral forum for dispute resolution. So of course, it should not come as a surprise at all that the more extensive view that is being taken of the SICC's international jurisdiction or extraterritorial jurisdiction underscores the SICC's primary objective is to attract judicial business. Now, does the SICC work in practice? Now, in its 7th year of operation, lawyers have used the SICC, have shared that a clear advantage of using the SICC, as opposed to traditional litigation of the General Division of the Singapore High Court, is that the designated SICC trial judge will handle all pre-trial case management conferences. In contrast, where proceedings go before the General Division of the Singapore High Court, due to resource constraints and other constraints, the pre-trial conferences are heard by assistant registrars. Lawyers have shared that the judge-led case management approach in the SICC is very effective in cutting out tactical gains and push the case along, thereby avoiding unnecessary delays. A second advantage is efficiency. It has been reported that as at 1st June 2020, the average time for disposal of the SICC disputes that have gone to trial was about 16.5 months. Now, finally, and the note on which I will end my presentation, is that the SICC continues to refine its framework and innovate. It has been announced by Chief Justice Sundaresh Menon that the forthcoming reform will see procedural rules incorporating international best practices from a variety of dispute resolution mechanisms and legal traditions. The rules have now gone through consultation. It is expected that the rules will be released by end of this year. I have not seen the final version, but I very much look forward to seeing what the final form they will take. So it seems that, to just conclude, that the SICC will become more international, but perhaps less arbitration-like, and positioning itself as a more neutral forum for dispute resolution. And with that, I end my very short presentation. Thank you.
Thank you very much. So already we can answer a little bit the question of how international truly is your court, or are these courts in general. And I think Singapore is indeed one of the courts that can be said to be truly international. But let's come back to that later. Now I would like to introduce the third speaker, and that is Stefaan Voet. And Stefaan is professor of civil procedure at Leuven University in Belgium. And one of his key areas, or his two key areas of research, are complex litigation, so collective redress, and also ADR. But he's also an expert in international commercial courts. He was one of the advisors also in Belgium, giving some consultation on the Belgium initiative. And he may have a little bit more of a critical view towards international commercial courts, because we've talked about this before, and especially, and maybe only, but let us know, the Belgium initiative. Stefaan, the floor is yours.
Thank you so much, Xandra, for this very kind invitation, also to Eva. I also had a PowerPoint presentation. I don't know, maybe you should project that, or should I do that? Let me see. Does that work? Yes? Very good. Okay. Now, what I would like to do in my 10 minutes is actually speaking about two things. First of all, how did the Brussels International Business Court was designed? How should it have looked like? And secondly, as you can see from the title, and it was already mentioned by Xandra in the introduction, the whole project failed. It failed because of 4 different reasons, I think, that I will discuss in a second. Now, first of all, it is important to know that the legislative track of that Brussels International Business Court was between October 2017 and the end of 2018, the beginning of 2019. And the timing is important for the reasons that I will explain in a second. The ratio legis was very clear. It was a little bit similar as all other international business courts in Europe. They were national and they did not explicitly refer to the Brexit, but of course, the Brexit was, of course, one of the underlying motives to set up this Brussels International Business Court. National and international economic and political developments that show the need for a Belgian high-level specialized English-speaking commercial court for B2B disputes. Now, how was this court composed of? That court had, and this is again, and I will come back to that in a second, typical Belgian, had 2 professional judges, presidents that were, one was Dutch speaking, the other one was French speaking, from the Market Court. And what is the Market Court? The Market Court is actually a section within the Brussels Court of Appeal. So we have courts of first instance, then we have Court of Appeals, we have 5. In the Brussels Court of Appeal, there is a specialized section, the Market Court, that deals with economic disputes, with financial disputes. And these are specialized judges. I think for the moment, there are 6. There are 3 full-time judges and 3 half-time judges. And out of these 6 judges, it was the idea of picking 2 presidents. Then there would have been an ad hoc chamber that actually would have dealt with all of the cases that was supposed to be composed of 3 judges. The president was going to be a Belgian professional judge, not from the Market Court, but from all other courts in Belgium, from the Justice of the Peace till the Court of Appeal, not the Court of Cassation. These judges could apply. There would have been a vacancy. They could have applied for that position. The only thing they had to do, they had to be able to speak English, and they had to have a knowledge of international commercial law. That president would then have been joined by 2 lay judges, Belgian or non-Belgian specialists in international commercial law. So they could have been, people from England, people from the UK, even people from the US or whatever. Now, it is important, and this is one of the point of criticism, that these people would have not been appointed as a judge in the normal way via the High Council for the Judiciary, but there was going to be set up a specific selection committee to appoint these judges. And later I will explain that this was also a point of criticism. The court staff would have been the court staff of the Brussels Court of Appeal. Jurisdiction issue is very easy. They would have had jurisdiction for the whole of Belgium. What kind of cases they would have dealt with? The private international case, disputes of a contractual or non-contractual nature that of course needed to have a cross-border issue, and only B2B disputes. It is important to underline that the parties had to agree to bring their case before the Brussels International Business Court via a forum clause in the contract, or by reference by another court. He supposed that there was a proceeding before the commercial court in Antwerp, and there at one point the parties decided we want to bring our case in English before the Brussels International Business Court, and both parties would have agreed, then it would have been possible to transfer the case to that BIBC. Now, the procedure would have been completely in English. All the paperwork, contrary to Germany, all the paperwork, the pleadings, the decisions, everything would have been in English, with one exception. In the case of third-party opposition, one of the issues that was raised during the consultation was suppose that you have a decision of the Brussels International Business Court and a third party wants to bring a third party opposition, then we cannot expect that that third party also brings that procedure in English. That third party couldn't bring that in Dutch, in French, or in German, but then everything had to be translated. Making reference to the point of Sir Geoffrey regarding the appeals, there was, the idea was to exclude the possibility for an appeal. The only thing that would have been possible was, as I mentioned before, a third-party opposition, and of course you could go always for issues of law to the Court of Cassation, the Cour de Cassation. The procedural rules as such, and this is important to underline, were actually based, or I should have said, were used as a point of reference, were the UNCITRAL Model Law on International Commercial Arbitration. And the whole idea was that it was going to be a self-supporting system. The idea was that if parties wanted to bring their case before the Brussels International Business Court, there should have been, or would have been, a registration fee of 20,000 euros. Now, as I mentioned before, the whole project basically failed. And I think there are 4 reasons. This is my opinion. I mean, you could have a discussion why it failed. There was a lot of discussion about that also in the media by different political parties. But in my objective opinion, I think there are 4 reasons. Some of them have to do with the court itself. Others have actually nothing to do with the court itself. First of all, there was the political context. The moment that the government launched the project in 2017, there was a sense of urgency. Brexit was coming, and they saw that in the Netherlands there was a project, in France there was a project, in Germany, and the Belgian government did not want to stay behind, and that is why they launched it. There was a committee, and I was member of that committee. Basically, we had a consensus quite quickly, I have to say. The government agreed with the proposal, and then it was brought before the parliament. And there, at the end of 2018, we had a political crisis. One of the parties that was member of the government was the N-VA, the Nieuwe Vlaamse Alliantie, which is the biggest political party in Flanders, and which is pleading for more autonomy of Flanders. I have to be very careful what I am saying now. Some people of the party want ultimately go to a confederal model, so the separation of the country with 2 separate states. And at the end of 2018, there was a big political crisis because the government wanted to ratify the UN Migration Pact, and the N-VA was absolutely against it, and then they left the government, which led to the fact that we had a minority government, and ultimately the Prime Minister, Charles Michel, who's now the President of the European Council, resigned. And this is one of the reasons why that later, in the beginning of 2018, the project actually failed before the Parliament, because there was no sense of urgency anymore. That is the political context, and illustrates the fact that if you want to create a new court, especially a court like that, that the political context is, of course, vital. Second reason is there was quite a lot of opposition, and unexpected opposition. For example, the Supreme Court, the Cour de Cassation, was basically absolutely against this project. In 2018, at the opening of the judicial year, the Procureur General of la Cour de Cassation, Albert Henkes, gave a big speech in which he was extremely critical about that Brussels International Business Court, first of all, regarding the procedure, because it would also have led to the fact that you could bring then a case in English before the Cour de Cassation if you would have appealed the decision before the Cour de Cassation, and these judges almost freaked out that they had to do something in English because it was not a language that they were willing to, that it was not their working language. Secondly, also the Brussels Court of Appeal, because the president of the Brussels Court of Appeal said, look, the backlog in my court is enormous. If you bring a case now, a case in appeal before the Brussels Court of Appeal, it will take you 3-4 years. In tax cases, 6 to 7 years before the case will be dealt with. And the president of that court said, look, first, let's try and resolve our normal cases before you are going to create what some have called a caviar court only for the rich. Let's not do that. But also the bar, some voices within the bar were also not very positive. For example, because of the fact that lawyers, Belgian lawyers and foreign lawyers could have applied to become a judge within the Brussels International Business Court. And the bar basically said, this is not what we should do. We should not, have lawyers sitting there as judges. So it was perceived as a privileged court for the rich. A reference was made to class justice, but also there were a lot of procedural exceptions. For example, the appointment of the judges, it was not going to be via the High Council for the Judiciary, which was a big thing in the beginning of the 90s, but they were going to set up a selection committee. So the threshold, the criteria, the quality criteria for these judges would have been lower or more easy than for professional judges. So that was, the second reason. I think there was quite a lot of opposition. In light of that, also regarding the budget, the Minister of Justice said it's a self-supporting system, people have to pay for that. But then when you read the little letters in the proposal, then of course the court staff had to come from the Brussels Court of Appeal, where already there was this backlog, and the president of the Brussels Court of Appeal was not very happy with that. The infrastructure would also have been provided by the Brussels Court of Appeal, which also did not make him very happy. And the idea was, we have other priorities. We should use these means. We should use this budget for normal cases and not for these international cases. And finally, there's the language issue. And I remember in 2018, I also said something about that. And I know, for example, in the Netherlands and in other countries, they are much more pragmatic, practical. Okay, you have judges speaking English, a procedure in English, which makes sense. But in Belgium, this is a little bit different. Languages, as you know, is an extremely sensitive issue still to date. You also have to look a little bit at the historical context. Don't forget that until 1935, all court proceedings in Belgium, also in Flanders, for example, in Antwerp and in Bruges, were almost all in French. So Dutch was not being used. And I'm not going to give a course on history, but the Flemish movement, for example, one of their struggles, one of their big battles at the beginning of the 20th century was making sure that Dutch could have been used in relationships with the government in court proceedings. So that act of 1935 was crucial and is still to date a very sensitive issue, because in Flanders, there are still voices that also, the judicial system is federal, that also want to separate that judicial system and that want to create a Flemish justice system only in Flemish. So when you introduce courts then that are an exception to that rule, that makes it extremely difficult. Also, the rules itself are not very clear because, for example, if you read the rules, suppose you had a Belgian company that had a commercial dispute with a company in the Netherlands, or a Belgian company that had a dispute with a company in France, then the language would have been normally Dutch or French. Then you could not bring that case before the Brussels International Business Court, which doesn't make sense because only English could have been used there. So this is, I think, also a reason why ultimately the project failed. To my knowledge, there are for the moment not ideas to resuscitate the project. It's not one of the priorities of the new Minister of Justice, but never say never. Thank you very much for your attention. And if you have any questions, please feel free to ask them.
Thank you very much, Stefaan. That was a very clear story, and also, as we know you, critical as to what has been going on. I think indeed Belgium is also special in the sense of this political context and language issue is really a hurdle in Belgium, and not only for this initiative, but sometimes also for other initiatives in improving civil justice or judiciary in general. Let us move on now to our last speaker in the panel. I also invite, but we also did it on the chat, participants in the audience to ask questions. It's a bit of a limit that we cannot really see each other, but I know you're there. So if you have questions and comments, please type them in the chat, and then we can discuss them after our last speaker of the panel. Our last speaker is Sandrine Giroud. And she's a lawyer and also a partner at Lalive in Switzerland. So we're moving to Switzerland now. And she's not an academic, but a practitioner. But that is also very nice to have on this panel, and not only on the second panel. She focuses on international dispute resolution and commercial litigation. So she's very well placed. And not only because of that, but also because she is involved in new initiatives in Switzerland to set up an international commercial court. And that's of course very interesting, because apart from London, also Switzerland is very important in terms of international dispute resolution, both arbitration, litigation, but also in choosing the applicable law. So we're very happy to have Sandrine on board, and we're looking forward to your introduction to the Swiss situation.
Thank you very much, Xandra. Hi, everyone. It's a pleasure to be here with you. It was really enlightening to hear all the previous panelists to explain the context of the initiatives and the courts that were able or were not able to take life in each jurisdiction. In Switzerland, we don't have any international commercial court, so that's why I decided not to have a PowerPoint to reflect that, but I'll try to give you more information about the context. And what I found interesting is that a lot of the points that I will mention echo some of the things which were mentioned, particularly by Stefaan and Burkhard. And Switzerland is probably not so different than Belgium. But before starting, just let me tell you a few things about my position. I am a practitioner. I do international litigation, and you don't get so many people doing international litigation in your own jurisdiction. Often you meet at conferences talking about private international law or international forums, and you hear all these brilliant ideas. You see how people do things differently in their jurisdiction, what works, what doesn't work. And then you come back home and you're stuck in a process which is slow and unsatisfactory to clients, because they want to have quick and efficient justice. And you see that often it is not the case. And you see that there are brilliant tools elsewhere. So it is with this in mind that several lawyers really practicing international litigation in Switzerland decided that we need to do better in Switzerland. People have this opinion of Swiss quality, especially clients. And when they when they have a problem and they have litigation in Switzerland, they're often surprised to the limits of the system, because it does not reflect what they expect of a jurisdiction like Switzerland. So the initiative I'm talking about very much comes from practice. And that was interesting to hear Stefaan mentioning that the Bar Association was not necessarily in favor of this initiative in Belgium, because what I'm talking about are initiatives from the Geneva Bar Association, of which I am a member of. I'm one of the board members, and I'm leading this working group, and also the Zurich Bar Association. So two of the leading commercial centers in Switzerland, which really want to make things better. And it is with this in mind that we've tried to set up different line of action, both at the federal but also at the cantonal level. As you know, Switzerland is a federal state, so the substantive law is regulated by the federal parliament, and so we all have the same law and the same procedure, but the organization of the courts is a matter for the cantons. So each canton has its own court organization. And in Switzerland, we have in our Code of Civil Procedure the possibility of having a commercial court, with the specificity that you don't get two levels of appeals at the cantonal level. You only get one chance to get your case heard, and then it goes up to the Swiss Federal Supreme Court. And that's the only option we have of a commercial court, and it is in our Code of Civil Procedure. So the cantons are not at liberty to create special commercial courts. If you want to change things, you need to change things in the federal law. The situation in Switzerland is so that there are 4 cantons which have commercial courts, in particular Zurich, which has its system, and Geneva doesn't have any commercial courts. And to give you an idea, the judges who addresses civil and commercial cases in Geneva do approximately half of that time, they deal with family matters and divorces. That's what they do. And then they get complex commodity trading cases or banking litigation matters with complex financial products. But that's what they do on the side of their general workload, which is family matters. So you get also, I'm explaining context because I think the same way as Stefaan explained the context in Brussels, you cannot understand why a court would be successful or not if you don't understand the context. I think we have less of a complicated context than Brussels because there is more unity at the federal level or within Switzerland, but still there are several tensions, and I wanted to mention them, and then I'll develop on what we're doing concretely and what could be done also in terms of improvement. So the first tension I'd like to mention is also something that I think Burkhard addresses. It's the notion of justice. What type of justice do we want? Do we want to have a judge which solves the problem, well, more or less in the right way when we have a problem? Or do we want to deal also with justice as a form of a commercial industry? Like, for instance, London is doing. London is making money out of its legal services with the commercial court. And one of the issues we have when we discuss with the judiciary, especially in Geneva, is that they say they don't want to try to make the court or the judiciary a business operation. So they don't want to have more cases. And I think that was really interesting to hear Man talking about that, to say in Singapore, you really want to attract more cases, whereas here, they're just happy to deal with the cases they have for the people they have in Switzerland. So that's the first thing. Do you want to have a more commercially oriented judiciary, or just a judiciary which addresses the problem of the people locally? The second point of tension is unity, which was mentioned by Stefaan. We also have the issue of national languages. As you may know, Switzerland has 4 national languages, and 3 of them are used for all public and official communication. These are German, French, and Italian. And so in Parliament, everyone speaks his or her own language, and all our laws are in 3 languages. And so but now the reality is, even in my firm, where we have an office in Geneva and Zurich, we tend to speak in English because people don't master German or French as well as English. So there is really a fear that English would replace our national identity and the very subtle balance of languages you have in Switzerland. So for some people, there is a high resistance to introduce English as a possible procedural language. Another point of tension, which I already mentioned, is federalism. The court organization belongs to the canton, and that means also the way you elect judges. And I think one of the successes of the London legal place is the quality of its judges. In Switzerland, judges are often elected they have to have a political affiliation. So they don't necessarily are political people, but you need to have a fair representation of each political party. So if you want to become a judge, you're not affiliated to a party, you just try to look which party still has some room for positions, and you try to go in that party. But just to say that the process doesn't make it so difficult to elect good people that you don't get the best of the best as judges. And oftentimes you get people who just don't want to be lawyers anymore. They just want to be judges, but it's not like in some countries and jurisdictions where you get really the best of the best, and it's really an honor to become a magistrate. Then I wanted, the last point of tension I wanted to mention is also the city versus rural areas tension. I mentioned that our initiative is led by Geneva and Zurich, but you get a lot of cantons who really don't care about these problems because they don't have the type of commercial matters we have, but they see as a threat that if we would open up to new commercial matters, or that we would attract the few commercial matters they have in their cantons in Zurich and Geneva. So that makes quite a lot of resistance to overcome, but it's not to say that nothing should be done. I think, as Burkhard mentioned, it is important to look forward and to do better. And so it may take a long time, but the improvement of justice will come automatically. And we're just trying to make it happen more quickly. So currently, the two projects which are in the pipelines in Switzerland are the development of a commercial court with an international section in Zurich. So Zurich, which has already a commercial court, is trying to set up a special chambers for international matters. And as soon as English would be acceptable as a procedural language, they would have judges who can adjudicate matters in English in that chamber. In Geneva, it's more difficult because we don't have any commercial courts. So the first step would be to establish a commercial court. And interestingly, we send a survey through commercial chambers in the region to understand what the economy and the industry wanted. And our main question was about costs, efficiency of justice, and so also the number of appeal degrees they wanted to feel safe with the judicial process. Because as I mentioned, a Swiss commercial court has only 1 degree of appeal. So you have the first instance at the cantonal level, and then you go to the Swiss Federal Supreme Court. But interestingly, most of the companies we approached said they prefer to have 2 appeal levels rather than 1. So they prefer to have a longer process rather than a shorter process, but more opportunities to appeal, which was a bit counterintuitive because we thought that they would have preferred a quicker and more efficient process. So that's something we will have to consider. And it is a question whether the General Council or the industry really understand the opportunities you could have with the commercial court, whether you need to have more education, or whether you need to acknowledge the fact that people just prefer to have more opportunities to litigate. And that's a factor you need to consider. So on the basis of this project, what we are doing are 2 things. So jointly between Zurich and the Geneva Bar, we're pushing for Parliament to introduce English as a procedural language in our Code of Civil Procedure. There is a revision of the Code of Civil Procedure in discussion now at Parliament. There are a lot of tensions about whether or not to agree to introduce English because of all the tensions I mentioned. And I think some of the points that Stefaan mentioned really came out also here in Switzerland. And we're facing quite a lot of resistance So our message is that it's fine for certain cantons not to want English, but let the cantons who want to have it, and they use it if they want. So it's really about the liberty of each cantons to organize themselves as they want. So that's on the federal level. And then on the cantonal level, each canton is trying to work to have the best structure in place. But that would mean having a court which is self-sufficient, because we all know that budget is really tight, especially now post-COVID. So we would need to find, to have costs to adjudicate these cases, which really matches the reality of the cost of such matter. And interestingly, when you ask the judges, for instance, in Geneva, how much a proceeding costs, they cannot give you a figure, because they don't have that, it's not their perspective, it's not how they approach the judicial process. So they will tell you, we may be happy to have such a commercial court, but we don't want to pay for it. And we just, okay, fine, let's take the process of looking at how much it costs, but they don't have data. And they don't have data on how many real high value disputes they have, how many people they use for these disputes. So that's why you really see also a tension between judges who are just dealing with the cases on an ongoing basis, and academics like you, like my fellow panelist, or me, like as an international litigator, observing the international developments, and while you're trying to educate them, but they just don't have the time or not necessarily the political will to do that, and they don't see it as a priority. So to conclude, I think to echo also some of the words our keynote speaker said, I think that whether you're conservative or not, justice will progress. There will be new digital tools, video conferencing, etc., which will come, and there will be an evolution. Slower or more rapidly, that will depend on the jurisdiction you are. But I think you really need to acknowledge the context, as Stefaan mentioned, and I feel that places like Switzerland and probably Europe are more conservative than certain jurisdictions which are like Singapore, which are very business oriented. Whether or not that's a good thing, it's not for me to tell, but we have to deal with the jurisdiction we have, and that's what we're trying to do in Switzerland. Thank you.
Thank you. We have a little bit of a technical hiccup here again, because now the idea was that we would show Burkhard's slides. I think that will work. Yes, that will come. But of course, first I would like to thank Sandrine. It's very interesting to see these different perspectives. And indeed, the idea of this first panel was not to have all great stories of how fantastic our courts are working, but also to see the different sides, the struggles, the initiatives. And we see both here for Belgium and for Switzerland that indeed also the language diversity, the court organization, the federalism, and etc., it plays a role. And if I compare it to my small country, the Netherlands, well, it's bigger than in Belgium, but it is less complex in the sense of the organization that we have. Also in the Netherlands, there were some discussions. We didn't mention the word caviar court really, but there was some ideas or discussions about having a two-tiered system of justice. And so there was some resistance. And there was also the question of where we would and how we would introduce the court, whether that would be in Amsterdam or in Rotterdam or in The Hague, because they are all internationally oriented. But then the choice was clearly for Amsterdam, because there it would function as a chamber, and that court had been recently renovated and was very well up to date in innovation, digital justice, etc. So that was, of course, and being the capital of the Netherlands, that was a good choice. So if I'm correct, we can see Burkhard's slides now, and just a couple of minutes to illustrate what you could not illustrate before based upon your slides.
Yeah, thank you. Maybe you move on until slide number 6. Okay, here we are. Just stay here. Here we can see the communication strategy. they have a very nice court building, service oriented. And if you move on to the next slide, can you move to the next slide now? Yeah. Here you can see the judges who are sitting in that court. They are presented, next slide, please, in a very professional way. So this is one of the female justices, and just click on. And here you can see she is presented with a kind of CV, the languages she is speaking, and also her work outside of the judiciary. So it's really the idea to compete a little bit with other international commercial courts by providing services from justices who are more than simple justices, but also have some professional experience outside of the courts. And when it comes to Germany, the language is of course also an issue, but it is rather within the Federal Supreme Civil Court, where the president is very much opposed to English as a language of the proceedings. And the political debate, which has also been mentioned by Stefaan and Sandrine in Germany, is strongly influenced by the fact that in the Federal Ministry of Justice, there are social democrats, and of course, they are not so much willing to permit special courts for, as they say, the rich. And this is the reason why 4 times the federal states failed to bring in the legislation they wanted to adopt. So I stop myself here, just as an illustration what is going on in Germany. Thanks for showing the presentation.
Thank you very much. And indeed, it clearly shows and different from how we usually perceive the judiciary, where you have a name and sometimes or often the name cannot be even found on a website, and judges are more at the background, anonymous, independent, and of course they are still independent, but to sort of put them forward and their qualifications in this way, that is indeed different from ordinary litigation, I would say. We have a couple of questions, and one is Adriani Dori, and we know her, well, at least Burkhard and I do definitely, because she used to work at the Max Planck and now she works in Rotterdam. And she asked whether, apart from the language issue that you mentioned, Burkhard, whether there are other reasons that you can think of that so far the case law in Germany is very limited or mostly absent.
Well, you need 2 partners to establish such an international court. Of course, the judiciary on the one hand side, and on the other side, the lawyers and clients willing to bring these cases to the international commercial courts. It might take a little bit of time and until they have more cases. For instance, in Paris, the idea is to combine or to give jurisdiction to the commercial courts, not only in commercial matters, litigation, but also in arbitration. And this, of course, raises the number of cases. The German approach is very much reluctant because there is no special law. You need a choice of court agreement, and to get such an agreement after the dispute has arisen is often a difficult issue.
Yeah, because I also, you answered the question that I had posed as one of the questions that we could discuss. Is there a genuine need for these courts? You answered that by saying yes, but at the same time, we have to acknowledge that in quite many of the courts, because it's not only in Germany, the number of cases is still relatively low. We have another question, Luana Picot, and I cannot see exactly where you are from, and I don't know this by heart. But anyway, Your question is, after these first years and the first cases before these national, international commercial courts, I wonder if these courts really find their place in the international landscape. And of course, that ties in again with the question, is there a genuine need? So our business is more inclined to go before these courts than to simply have recourse to arbitration. So indeed, is there a genuine need for these courts? And this commentator says that I must admit that I'm quite sensitive to the arguments outlaid by Professor Voet when exposing the critiques of the Avocat Général of the Cour de Cassation. And that is what this commentator asks to the panel. Who would like to take the floor?
I guess I can have a go at this question first, and I would like to then hear from the other panelists. Right. I think that's quite a good observation, and I think it's an important question to ask. There genuinely for such courts. I can only speak from the perspective of the Singapore International Commercial Court. I think the numbers are still relatively low, although there's a general increase in the number of fresh filings before the SICC, and this in respect of applications to the SICC in respect of the international commercial arbitration. In terms of non-arbitration cases, fresh filings, that means where parties designate the SICC in their contracts, not as optimistic as they would like to see, but there are many transfer cases. So I think the evidence from usership is not particularly clear, right? Because if parties are willing to transfer their cases, does it indicate that they are willing to use the SICC based on what has happened, even though they had not, chosen SICC by a jurisdiction clause? Because you can imagine the SICC was only launched in 2015. These contracts might have been entered into way before that. Now, a second observation I would like to make is that I think lawyers and in-house counsel might be unwilling to change the boilerplate clause for dispute resolution in the contract. A lot of these clauses are described as midnight clauses, hardly looked at during the contract negotiation stage. So if an arbitration clause works, why change it to the SICC clause, for instance? So that might be something we need to take into account. So I think from usership, not particularly strong evidence that there is a surging need for the International Commercial Court. But I think from the perspective of innovation, right, to just echo what Sir Geoffrey said in the keynote, is that I think there's a need from the perspective of innovation. The SICC is like a specialized platform to sort of experiment with these new features in a way that will not affect access of justice for other litigants to commercial disputes, but might be smaller and not so international in nature. So that's my 2 cents first. Thank you.
Well, I think you're raising a very good point. I remember, it's an anecdote. I remember during the preparations we invited, I think, one of the presidents of the biggest business organization in Belgium. And the man actually said, I only have one question. Persuade me why I should go to that Brussels International Business Court instead of using arbitration, because we have a good arbitration institution now. Persuade me. And this was also one of the issues that Avocat General was making reference to, a little bit more in detail, of course, but he said, you are actually making an arbitration court within the judiciary. And this is not our task. You should not do that. It's, of course, okay that parties can have arbitration. That's why I think one of the panels that you have set up in this conference is the link between international business courts and arbitration. I think that's a very good idea. And it's also something we had, I remember, in the debate we had in Belgium.
Maybe one idea in this regard: arbitration does not fit to all types of disputes. And especially when you have multi-party disputes, it might be difficult to organize arbitration. And for this kind of disputes, it might be good, especially when you have international disputes, to have specialized courts. Of course, we won't have many cases, that's for sure. But the value of amount of these cases, especially when they are complex, are considerable. And this is also good for the general justice system, on the one hand side, to be open for such kind of cases, and also for the funding of the justice system as a whole, it's also interesting to have high-value cases. I will never forget, I was once in a case, it was a cartel damage claim case in Düsseldorf, or in Dortmund. It started in Dortmund, and there was a fee to be paid by the plaintiff in order to start the proceedings in Germany. And the defendant already raised the question whether the plaintiff would be able to pay all the litigation costs in case they would win. So the other side would win, the defendant would win. And the presiding judge simply smiled and said, well, the filing fee which has been paid to this court by the plaintiffs helps us to run the business of the whole court for several weeks. So this is something to be considered too. And this is also one of the arguments in the German discussion.
And if I may add to that, I think Burkhard is absolutely right. That there are certain cases which are not fit for arbitration that will go to litigation. I'm not so sure about the multiple party cases, because from what I'm seeing, they are as complex, if not more complex, in certain jurisdictions when you go to court litigation. But what we're seeing, because we're having that discussion also with the arbitration chambers, they really do not see that as competition. They see that as an addition, because you see that courts already are having to address commercial cases that could be addressed in a better way. Those cases are not going to arbitration. And so it would be a way to address those cases to make it better. Then whether we can increase more the number of court cases versus arbitration, that's a different, but I think it would be very marginal. We just here, I think it's more observing that there is a problem with the way certain cases are adjudicated now by court and finding a solution. And it's not getting a position between court and arbitration.
If I could add something to this, I think I have asked myself the question just listening to you, whether for the future a jurisdiction can really be successful without actually a specialized international commercial court, because it seems that this whole area of commercial law is moving into more and more specialized direction with new technologies, with crypto, with smart contracts, where a normal judge would actually not necessarily be keen on dealing with all those questions. But it requires judges who are very motivated to work in this area, who are specialized on those types of questions. And I also think if the English language remains an issue, that's an issue that needs to be solved, because I think without English language, such a court will not be ultimately successful in the competition with other countries. And that reminded me, especially when Sandrine said what the resistance is in Switzerland. We had the same issue at the university level with courses in English. And until we convinced our colleagues that they are not concerned by the language problem, we had a problem. And once they realized it concerns only us, they were fine with it. And it seems to me it's a similar exercise, explaining to colleagues across Switzerland that this is a very specific question that concerns two particular jurisdictions within Switzerland. To move forward with this. And I think the opportunity in Switzerland is there now, also with the project Justitia 4.0 and the work on digitalization. So there is a lot that is moving anyway. And I think it's the very best opportunity to get that question up to the highest level in Switzerland.
I see one more question and then we will wrap up, because we're already 10 minutes behind the time. Some questions have been answered in private, if I see this correctly, but Margarita Salvadori has a question and saying Singapore is a member of 2005 Hague Convention. If I understand correctly, the CICC does not distinguish between exclusive and non-exclusive choice of court agreements. Can you please elaborate on that? Thank you. So that would be for Manjip.
Thank you for the question. Yes, Singapore is a member of the Hague Convention on Choice of Court Agreements. It has already been implemented as local law. perhaps I wasn't quite clear in my presentation earlier. The SICC does not distinguish between exclusive and non-exclusive choice of court agreements when it comes to the rules for when you should decline to assume jurisdiction, right? Not to say that it doesn't distinguish between the two types of choice of court agreements. In fact, where the clause is in the sense silent on whether it's exclusive or non-exclusive in nature, it will be presumed to be exclusive, right? And then the further point, which is a complication arising from Singapore being a member to the Hague Convention, is that you might have cases which will fall within the Hague Convention that could be heard by the SICC, but you also have cases that do not fall within the Hague Convention, but could be heard by the SICC or even the High Court. So I have written much about this. I'm happy to share those materials. Yeah, I am aware that the time is running out, so I'll hand it back to Xandra.
Does any of the panelists want to add a last comment? No. Then I will make a very last comment to wrap up this panel. Of course, many can be said and much more will be said in this afternoon today. So I will just briefly conclude that I very much agree with Eva that maybe the question of is there a genuine need for these courts can be answered in the affirmative, indeed looking at the challenges that we at present have and that we will have. So maybe it is not about attracting a high number of cases per se, which can of course, and maybe in Switzerland that is perceived and differently by the judiciary, but for a local legal market and an international market, this can of course be also economically attractive. But it is also for the challenges that we do have in digitization, in dealing with smart contracts, with complex litigation, etc., that perhaps a dedicated court for certain international commercial disputes or a chamber within a certain court, which is then not setting up a new court, but as in the Netherlands, having a chamber within the court that deals in the English language and using everything that's out there to make the best out of these complex litigation, to have that go ahead. And I think that then we can answer, yes, we do need those courts, even if it's only for innovation and to keep up with all the challenges that we have. Again, how to organize that specifically, that is then up to the country. Good, thank you very much to all panelists for your interventions, which were very interesting as always. We are a little bit behind, but I assume we will still stick to the 15 minutes of break, coffee break, to stretch your legs, have a coffee, etc. So in 15 minutes, we will resume with the next session, which will be the practitioner's perspective on the experiences with the courts in the different countries. I hope you will join us again, and in any case, have a very good day. Thank you again to the panelists.